Ladies and gentlemen, please take your seats. And welcome to our panel on technology change and the future of the Fourth Amendment. In the spirit of technological futurism, please turn off your cell phones, pagers, and BlackBerries. We have special reason to turn those off because the Supreme Court told us yesterday that although we do have an expectation of privacy in our cell phones and BlackBerries, it's not a strong enough one to prevent our employer from searching our messages for exceeding workplace limits, even after they've promised that they won't do that. The court's Quant decision yesterday reminds us of the remarkable challenges that we now face to the Fourth Amendment. Justice Kennedy talked about the need of progressing prudently and cautiously in a moment of technological change. But is prudence and caution adequate to protect Fourth Amendment values in a world of new technologies? Prudence has not always been the watchword of our greatest defenders of the Fourth Amendment. The profit of translating the Fourth Amendment in an era of technological change is my hero, Justice Louis Brandeis. It was in his dissenting opinion in the Olmstead case during the era of Prohibition that Brandeis insisted that it was necessary to translate Fourth Amendment values to ensure that citizens in the 20th century, in the age of radio, had the same amount of privacy that people in the founding era took for granted. Remember that in Olmstead, a majority of the court in this very wooden and literal-minded opinion said that it wasn't a Fourth Amendment search for the government to put wiretaps under the office of a suspected bootlegger because the Fourth Amendment was defined by property rights, no trespass, no Fourth Amendment violation. In his visionary dissenting opinion, Brandeis said that a far smaller violation had been held to violate the Fourth Amendment at the time of the framing. And he told the story of John Wilkes, whose private desk drawers were searched and seized by King George in an effort to identify him as the author of a seditious libel. And then in a remarkable passage, Brandeis looked forward to the age of cyberspace. We know from this great new biography by Melvin Urofsky that Brandeis originally wanted at this point to refer to a new technology, television, developed by the General Electric Corporation. This is 1927. And Brandeis imagined a day when television would be two-way and could actually take pictures of papers in secret desk drawers and then introduce them in court. He was persuaded to omit this reference by a skeptical law clerk, Henry Friendly, who went on to distinguish himself as a rather cautious jurist. But Brandeis nevertheless included this incredible passage in his Olmstead dissent that looks forward to the age of cyberspace. He says, "Ways may someday be developed by which it's possible, without intruding into secret desk drawers, to introduce images of papers and introduce them in court. A far smaller invasion was a violation of the Fourth Amendment at the time of the framing. We have to translate the amendment to take account of these new technologies." As you know, it took the court more than 50 years to answer Brandeis's challenge in the Katz case, where it says that we do have an expectation of privacy from virtual searches, but Katz included two doctrines that undermined its utility as a protection for privacy in an age of digital searching. First, the court said that we only have expectations of privacy that society reasonably accepts. And of course, as invasions become more widespread, expectations diminish with a corresponding diminution of constitutional protections. Second, the court went on to say that when you surrender data to a third party, if I give my data to the bank, I've lost all expectation of privacy that the bank won't share my data with the government. And now in the age of Google, when our data is stored not in desk drawers, as at the time of the framing, but in the virtual cloud that is on distributed servers maintained by Google and Yahoo, this third-party doctrine effectively means that I can no longer expect privacy in my virtually stored papers that would have been taken for granted at the time of the framing. There's one final puzzle that we're going to talk about today, and that's that the greatest threats to privacy at this moment, at the dawn of the Web 3.0 age, come not necessarily from government, but from private parties. Right now, the organization that has more control over privacy than any king, any government, or any legislator is Google. And there's a woman at Google, the Deputy General Counsel, Nicole Wong, who's responsible for deciding which YouTube videos to take up or put down when she receives requests in the middle of the night from the Thai government or the Turkish government. and also when to turn over our search terms in response to government subpoenas. Likewise, Facebook has greater control over privacy in its decision about how long to store the youthful pictures that return years later to deny us jobs, these drunken Facebook pictures that are now routine, almost part of our digital dossier, could be deleted if Facebook chose. They could store those photos for 3 months unless we chose to keep them forever. But Facebook has made a business decision that it wants to keep the data forever with huge implications for privacy. One question we need to talk about is how can the Fourth Amendment, which generally restrains government, adequately protect privacy in the age of Facebook and Google when giant private corporations are often acting in conjunction with the government to threaten and protect privacy in unforeseen ways? The answer is not clear, but the challenge, the need to translate the Fourth Amendment, is one that Louis Brandeis would have insisted on. We have a remarkable panel to discuss these fascinating issues with. I'm going to introduce them. They're going to talk briefly for about 5 minutes or so, and then we're going to have a discussion, and then we'll leave at least a half an hour for your questions. We're going to begin with Susan Bandas. I'm going to keep these introductions short because you have the full bios, but it's such a pleasure. I was so delighted when I saw that Susan was here. She's been doing such important work on Kylo, on virtual searches, and on emotion in the law. She is the Distinguished Research Professor at DePaul University College of Law, and she's going to set the stage for us by talking, this is in some ways the most challenging assignment. Susan, you're going to describe changes in the law of the Fourth Amendment in traditional and new technological context and describe the similarity and differences between these contexts. Thank you so much, Susan.
Thank you so much, Jeff. It's a delight to be here at ACS. And yes, I think in 7 minutes I am planning on going through the history of the Fourth Amendment, determining what technology has driven and what changes were not driven by technology. So I think I will take my entire 7 minutes to do that. I think it's fair to say, actually, when you look back at the Fourth Amendment doctrine and its development that way, that changing technology has been, if not the most, and certainly one of the major forces driving the development of Fourth Amendment doctrine. And I wanted to place these changes in the context of Fourth Amendment doctrine generally by identifying what I think is a useful way of thinking in terms of 3 basic Fourth Amendment questions. The threshold question, of course, as you all recall, is whether the Fourth Amendment applies to the conduct in question at all. Now that raises, first of all, the issue that Jeff mentioned, which is the issue of whether we're dealing with public or private conduct, which is a really important question. But also it limits government conduct only if that conduct amounts to a search or a seizure, and more specifically, a search or a seizure of a person, a house, a paper, or an effect. Now, these definitional questions, what's a house, what's a search, at one time may not have seemed particularly difficult, but they have proven difficult for one overwhelming reason, and that reason is technology. I will return to that point shortly. The second type of inquiry is, assuming that the search or seizure threshold is met, has the government complied with the substantive requirements of the Fourth Amendment? Does it have the requisite level of suspicion for the search, which is usually probable cause? Did it get a warrant? Did it show an exception to the warrant requirement? Was the search reasonable? And I'm going to talk briefly about that. And finally, the third inquiry is simply, assuming the Fourth Amendment has been violated, what should the remedy be? And I will not talk about that, but my ACS issue brief about the exclusionary rule is somewhere in this room as part of the continuing legal education materials, and my thoughts are set out in that. So really a tremendous amount of what I believe we'll be talking about today, although certainly far from all of it, rides on the first of the 3 questions that I identified, whether the challenge conduct is a search or a seizure at all, and if not, the Fourth Amendment inquiry is over. Of course, government action might be limited in some other way, and this is becoming increasingly important in dealing with a number of the issues we'll be talking here: statute, state constitution, the Equal Protection Clause of the U.S. Constitution. But the Fourth Amendment simply falls out of the picture if we can't meet the search threshold. And this has been a doctrine that has been really pretty much all about the court's struggles with changing technology, as Jeff says, going way back to the Olmstead case in 1928, in which the court first grappled with the technology of the telephone and how the Fourth Amendment should deal with that. Most of the problems that bedevil the court's efforts to regulate technology are in cases about the definition of search or seizure, so I'm going to focus mostly on those concepts. The notion of search or seizure, until the advent of the telegraph and the telephone, was based on spatial, property-oriented notions of privacy. Breaking down doors, rifling through papers, opening steamer trunks. These were trespasses under common law, whether they were done by the government or whether they were done by a private person. They were invasions into physical space. When the subject of the search wanted to keep something private and it got made public, that was quite against his will. There was no nuance there, no difficult issue. The question of whether a search had occurred just wasn't very complicated. And if the king's men walked off with the homeowner's private papers, that was a seizure, also not very complicated. To explain how things got so complicated, I want to focus on two aspects of the search doctrine, both mentioned by Jeff and both of which I know the other speakers will talk about in a lot more detail. Third-party doctrine and reasonable expectations of privacy. Third-party doctrine. Even in colonial times, it was possible to be betrayed by a friend. Your friend could rat you out for, let's say, seditious libel, talking trash about the king. You always assume the risk that your friends are gossips or even snitches. But the court has taken two steps in this analysis that don't necessarily need to follow as a matter of constitutional interpretation. First, the court has held that you assume the risk that your friends are government agents. Essentially, the court said that what you expose to one person, you have exposed to all people, even to the government. You have no right to decide to share information with a limited group of people for limited purposes. Note that this formulation focuses on the actions and expectations of the individual target of the search and not on the actions of the government agent. It thus avoids an important question. What kinds of government actions do we want to permit or discourage? Or, as Justice Marshall once asked, what risks should people be forced to assume in a free and open society? Second, and here's where technology comes in, the court has held that you assume not only the risk that your friend is a snitch, but also the risk that your friend is wearing a wire. The technology, they say, just ensures a more accurate transmission of information that would be shared in any case. So the mode of intrusion, says the court, is irrelevant. The problems with assumption of risk analysis became quickly apparent, and Jeff has alluded to both Smith versus Maryland and U.S. versus Miller, the telephone case and the bank account case, so I don't have to rehearse those as well. But the idea that we willingly assume the risk that by using the phone we've shared our phone numbers called with the government, or by using a bank we've shared our bank statements with the government, seemed like a stretch even at the time. But now that we're in a time of ubiquitous technology, it's kind of baffling to imagine how one declines to assume the risks inherent in the modern world. In this world, we're constantly putting our data out to third parties, unless we are Luddites who have taken ourselves off the grid. And in this world, technology, by the way, also has the capacity to observe us even when we don't willingly engage with it. Think, for example, about cameras on street corners or Google Earth. Second point, reasonable expectations of privacy. In Olmstead, the court considered whether tapping a phone line implicated the Fourth Amendment, but the phone line ran outside the home. So there was no physical trespass, and the court rejected the claim. By the time Katz came along in '67, phones were ubiquitous. The court knew by then that it needed to disentangle Fourth Amendment law from property law and from the notion of physical trespass. That whether a person's property was physically penetrated was the wrong question, but what was the right question? The opinion focused on expectations of privacy. It focused on the fact that Katz took steps to keep the conversation private. But as Justice Harlan's crucial concurrence added, it also matters whether that expectation of privacy is one that our society would recognize as reasonable. This reasonable expectation of privacy rationale has proved very problematic. Justice Scalia called it self-indulgent and circular, and in this regard, he has a point. Of course, he would instead look to the original meaning of the Fourth Amendment, and I am hoping that we'll have time today to discuss how his approach has fared. So briefly then, not all the problems in defining searches involve challenges to technology. For example, people are often surprised to learn that they have no reasonable expectation that government agents won't go through their garbage or walk on their fields. But technology is what has made the property paradigm unworkable. Much of what we've kept private or want to keep private is no longer tied to a physical space, and even when it is, technology has given government far more ability to invade those private spaces. GPS, tracking beepers, thermal imaging technology, high-powered binoculars, low-flying planes, et cetera, et cetera. Okay, so just a couple of brief comments then about the substantive reach of the Fourth Amendment and the particular problems of technology there. First, a warrant must describe particularly the thing to be seized, and it must be appropriately limited in scope. This has proved a particular problem for wiretap cases and cases involving computer and internet files, as some of my co-panelists have written about in detail. Second, the issue of the proper scope of a search incident to arrest. Very interesting question. Police are allowed to search anything on the RSD's person, not only for the sake of safety, but also to look for evidence and preserve it. So, should the police be allowed to search through our smartphones, our BlackBerries and iPhones that we carry on our persons, packed with the intimate details of our lives? Third, I don't know if we think about cars as technology anymore. We hardly seem to, but indeed the whole issue of movable objects that aren't spatially set in a particular enclave has been highly problematic for the court. And finally, the issue of probable cause. The requirement of probable cause helps control the government's ability to target individuals for investigation. But increasingly, the government is gathering information not retail but wholesale. Surveillance cameras, airport scans, massive phone taps. Increasingly, the court has held that these wholesale methods are permissible with no requirement of individualized suspicion at all, especially when what they call special needs, like the war on drugs or national security, are at stake. So as technology becomes more ubiquitous, the problem has become not only discriminatory searches that stigmatize and burden individuals, but indiscriminate searches that burden many of us. And I will stop there for now.
Thank you very much indeed, Susan. We will next hear from my friend and colleague, Oren Kerr. Oren is a professor of law at George Washington University. He is doing some of the most interesting work in the country today about computer crime and criminal procedure, trying to solve this dilemma that we're talking about, and namely come up with new doctrines that will protect Fourth Amendment values in a technological age. Oren.
Thanks, Jeff. It's a real pleasure to be here. I wanted to thank the ACS for inviting me. ACS crowds are really my favorite audiences to speak in front of. Engaged, smart, and inclined to disagree with me at every step. So it's sort of all three are great. So I wanted to start by framing this in terms of the question of should we be optimistic or pessimistic in terms of what might happen with the Fourth Amendment in new technologies. The standard account you find in the scholarship is pretty pessimistic. There's a lot of dystopian visions of Big Brother in which the major choice is whether to title your article The End of the Fourth Amendment, The Death of the Fourth Amendment, or A Crisis of the Fourth Amendment. And I see the issue brief that was standing out here by Jay Stanley went with option C. So that's a big choice. But I'm actually much more optimistic about what the courts are going to do in this area. I think yesterday's decision by the Supreme Court in Kwan is one data point here for why we should be optimistic. The court did not really answer, in fact, they didn't at all answer, these very difficult questions about how the Fourth Amendment might apply in the case of remotely stored text messages. But they first indicated that they care a lot, they want to get it right, and they had a positive citation to Katz versus U.S. and a negative citation to Olmstead, which at least indicated that they were thinking about this in the grand arc of Fourth Amendment law as being an area where they're interested in protecting privacy. Other signs from the lower courts would include a decision by the Ninth Circuit en banc, United States versus Comprehensive Drug Testing, an en banc decision by Alex Kaczynski, offering a tremendously privacy protective, albeit slightly lawless, framework for how to protect the privacy of searches of standalone computers. So courts are struggling with this, judges are struggling with this, But the framework, to me, that's most important is that they care and they want to get it right. Something which 10 years ago we did not know or even, I think, really expect would happen. So this is an area that across ideological lines, judges care about a lot. And one more data point in terms of the ideological line idea is the justice at the Quan oral argument that was most strongly in favor of privacy protection was Chief Justice John Roberts, something we didn't, I think, expect. So this is an area where across ideologies, the judges want to get it right and they care and they're looking for ways to figure this out. And that brings me to an idea of how they might try to do that in the case of the Fourth Amendment being applied to computer networks. And so I think the goal of applying the Fourth Amendment to new technologies generally should be trying to match how the Fourth Amendment applies in the new environment, the new facts, to how it applied in the old facts. And the idea is to think about new technologies not as some new world that's totally different from anything we've ever seen, but rather thinking of new technologies as a substitute for old technologies. What technologies generally do is let us do something more easily than we used to do it before, more cheaply, more quickly. And so we should think about new technologies as substitutes for old ones. How might that apply in the case of computers and the internet? Well, I think it helps to think of all communications networks as tools for doing remotely what we used to have to do in person. So any communications network, whether it's the postal network or the phone network or the internet, is allowing us to send communications across space without having to leave where we are located, or at least not having to go very far, maybe out to the mailbox. But basically, the network does for us what we used to have to do individually. And what I think that lets us do is come up with network substitutes. We can think about the information that would have been available to the government in the old technology and try to match the rules for what information would be available to the government and under what privacy protections under the new technologies. So what might some examples of that be? Well, think about if you had to deliver a box of private documents to a friend. Well, you'd have to leave your house. You'd have to walk, say, across town. Let's say it's somebody who lives in your neighborhood or across town. You walk outside and then deliver the box. Let's say the government wants to watch you do that because they suspect there's drugs or some evidence of crime inside the box. Well, what can the government learn without implicating the Fourth Amendment under traditional Fourth Amendment rules? They can know when you left your house. They can watch you and know when you were traveling. They can know when you arrived. They can get the outside of the box, the shape of the box, the size of the box, because they can just see it out in public. But what they can't do is open the box. They can't find out what's inside. That implicates a reasonable expectation of privacy, requires a search warrant based on probable cause. So I think we can model communications networks by thinking about how networks replace that traditional physical transaction with an online transaction. So sending an email, for example, is a lot like delivering the box. The network does the delivery for us. It serves as our agent, so we don't actually have to go outside. But the network generates information used to deliver the email, which is analogous to the information that the government would be allowed to observe in public if it had been the case of a physical box. So what are some examples of that? Well, the to-from email address is a lot like the location information of the to-from physical address. The size of the email is a lot like the outside dimensions of the package. On the other hand, the contents of the email, the actual payload of the communication, is a lot like the inside of the box. So a way of translating the Fourth Amendment to the network environment, to the internet, would be to substitute the electronic transaction for the physical transaction and say that the content of the communication should be protected by the Fourth Amendment based on the traditional warrant requirement, but the non-content information, which would be analogous to what the government could observe in the physical case outside, would not be protected. So the simple rule that emerges from that is contents should receive Fourth Amendment protection, non-contents should not receive Fourth Amendment protection. It's not a perfect answer. There are lots of potential difficulties with that approach of applying the Fourth Amendment to the internet. But I think it's an example of how we can, rather than get really worried and think, well, we rather have total privacy, no privacy, and fear what the courts might do. We can just break down technologies into their functional roles and think of substitutes from the old to the new, drawing analogies between older technologies and newer technologies, not necessarily based on just the battle of analogies, but rather on a functional sense of what these network technologies do. And I think if we do that, courts are going to have a Fourth Amendment in the online world that looks a lot like the Fourth Amendment in the physical world, in the traditional environment. Now, you may not like that, in which case you're probably not going to like the Fourth Amendment in the network environment either. But it's at least a way of making sure we get the same sort of balanced concept in the network environment that we are used to in the physical world. So that's one approach, and there are certainly others, and I look forward to questions, but wanted to offer that as one way of doing this very difficult task of trying to come up with these new rules, an effort that the court started with in Kwan but ended up not doing because they wanted to decide that case narrowly. Thanks.
Thank you very much indeed, Oren. We will now move from the clouds into some specifics, and we're very fortunate to have Elizabeth Joh, a professor of law at UC Davis Law School, who teaches criminal law and procedure and has written very provocative and thought-provoking scholarship on the Fourth Amendment issues raised by DNA evidence and DNA collection. I think she'll tell us about that and of other applications of the Fourth Amendment in particular context. Professor Joh.
Okay, thank you. It's an honor to be here. I also thank the ACS for inviting me. It's always a pleasure to be with ACS folks. I've been asked to talk specifically about a context in which the Fourth Amendment has been particularly a challenge, and I'm going to focus on DNA evidence and how that has challenged our thinking about the Fourth Amendment. So ever since British scientist Alex Jeffreys discovered accidentally in 1984 that despite the fact that all of us share virtually identical DNA, in other words, there's just a tiny percentage that changes between person to person. It's that tiny percentage that actually could be used for a unique identifier. Since that time, DNA has become an extremely and indispensable, important and indispensable part of the criminal justice system. And there's two factors that are going to pretty much guarantee that DNA is here to stay as part of policing and criminal justice. First, we're becoming ever more sophisticated in our uses of DNA evidence. We can analyze ever smaller quantities of information looking for DNA in it. We can also examine particularly degraded pieces of genetic material, which 10, 15 years ago we wouldn't have been able to do. And then second, it's becoming ever more cheaper to analyze DNA. So to give you a kind of a brief comparison, today an entire genome scan, a genome is the roughly 30 million base pairs that make up the human genome. An entire genome scan costs about $300,000. In 2003, it cost $300 million. So getting cheaper all the time. And in terms of the Fourth Amendment, I think there are actually two similarities here between computers and the internet on the one hand, and DNA evidence on the other. First, and here I'm going to disagree with Oren just a little bit, and that is I think that computers and the internet on the one hand and DNA evidence on the other actually do resist easy analogy. I think that one of the greatest challenges here is in the realm of new technologies, finding the best fit. What is the best way of thinking about what this new technology represents? This is a serious problem, of course, when the development, the sensible and comprehensive development of the Fourth Amendment depends on judges choosing the correct analogies to help sort of progress our thinking when it comes to the Fourth Amendment. Second, whether we're talking about computers, the internet, or DNA, we're actually, I think, in a state of cultural change, or more specifically, a state of generational change in our thinking about these things. And of course, why does that matter? Well, it all matters because of what our expectations of privacy are. So whether you are a member of Generation Y or Generation Z, you may have very different views on privacy than earlier generations did. And when it comes to your expectations of privacy with DNA, it's not clear what they are exactly. They may be somewhat in flux. You may feel that you have some privacy in your DNA, but how much privacy do you have exactly? Well, that may be changing slowly, and social institutions may be helping that along, social institutions outside of the criminal justice context. So one example I have in mind is you witness the recent announcement by the University of California at Berkeley that the entire incoming freshman class of 2014, ready to start this fall, will be asked to submit saliva samples for a class-wide genetic testing educational project. It's a completely a voluntary basis saliva sample, but the idea here is that you would have a kind of mass genetic testing experience. In the policing context, I want to mention a couple of important questions about the use of DNA evidence with regard to the Fourth Amendment, and some of which I hope will be addressed in the Q&A section. So first, it seems clear that DNA databases are here to stay. All states collect DNA from some groups of offenders. The first criminal offender databases began in the 1980s, and they've basically slowly expanded the scope of who must provide a compulsory sample. When it comes to the Fourth Amendment, courts thus far have uniformly rejected Fourth Amendment challenges to this kind of DNA sampling. And the real question, of course, is how far can that DNA sampling go? The challenge that's pretty much on the horizon and basically right in front of us is the mass sampling of not those in a post-conviction status, in other words, those who are incarcerated on parole or probation, but arrestees. So does a compulsory inclusion of DNA samples from people who have simply been arrested, not charged, not actually convicted yet, does this violate the Fourth Amendment? Second, today the FBI runs CODIS, which is a system that coordinates the DNA databases of all 50 states, the federal government, and the District of Columbia. And typically what police are doing when they're trying to use CODIS is they're trying to find whether sample 1 actually matches sample 2, or rather, more specifically, DNA profile 1 matches DNA profile 2. Well, in other words, what they're really looking for is a 100% match. But the question here is, what if the match isn't 100%? Should that also be something that the police have access to? What if the police actually intend to look throughout CODIS to see whether or not there are such partial matches, in addition to, of course, whether there'd be a 100% match? If these so-called partial match searches or familial match searches are being used, are these reasonable searches as a matter of the Fourth Amendment? Third, what about DNA expectations of privacy in individuals? I pretty much can guarantee every one of you, when you leave the panel today, you're going to leave a little bit of yourselves behind. You're going to leave a little bit of saliva on your water glasses, your coffee cups, your Diet Coke. You might shed a few hair follicles. If you're particularly clumsy, maybe you'll spill a drop of blood with a paper cut. You're going to leave something behind, and that's going to contain your DNA. So the idea here is, should the police, for example, be able to take that DNA and analyze it without A, you knowing about it, and B, not having any kind of detached third party overseeing the police taking and analyzing this material? As Susan already mentioned, and the question to be asked here, of course, is this a Fourth Amendment search at all in the case of discarded or shed genetic material? And then fourth, how are social practices changing with regard to the reasonable expectation of privacy when it comes to DNA? So I've already mentioned the University of California, Berkeley proposal, which will be the first mass genetic testing conducted by a university. So what about personal or recreational genomics? And what I mean by that is there's a host of services available on the internet to you now. You could look up on your BlackBerries or iPhones or whatnot, where you could order a phone over the phone or by email, a spit test, a collection test, and find out what these companies claim could be a variety of predispositions to diseases, health conditions, or a variety of other things which may or may not be based on hard science, but a number of things based on your genetic material. So could be everything from whether or not one would get Alzheimer's, has a predisposition to Alzheimer's, to whether or not one efficiently metabolizes caffeine, which allegedly or reportedly OMB Director Peter Orszag found out after being alarmed about his Diet Coke habit. So luckily for him, he finds out that he has this efficient caffeine metabolizing gene, so he can go on his merry way and drink gallons of Diet Coke. So to sum up, overall, or is this a world of optimism or pessimism? Again, to kind of borrow a bit from what Orange just said. Should we be concerned about a world in which we are moving towards what might be, on the one hand, pervasive, i.e. nasty and pessimistic, genetic surveillance? Or, on the other hand, as the British Human Genetics Commission wrote in a report just last year, are we going to be moving towards a world in which genetic profiles are going to be in time as common as having an email address or a cell phone number? Sometimes inconvenient, but tolerable because it is perceived as being highly useful. So I look forward to your questions.
Thank you, Professor Zhou, for that arresting and provocative presentation. You have heard 4 law professors address this question from the high and sweet realm of theory. We're now very fortunate to have a real practitioner, someone who engages with these issues in a practical way. Mark Zwillinger runs one of the more interesting boutique law firms that I've heard described. He specializes in cybercrime, information security, privacy surveillance, and subpoena compliance. What a wonderful and interesting practice that is. He frequently represents ISPs, social networks, and email providers in disputes with the government. Before launching this practice, he was a computer crimes prosecutor with the Department of Justice. And Mark Zwillinger, we're very much looking forward to your presentation. Thank you for being here.
Thank you for having me. I just have 2 observations I really want to make before we go to the interactive portion of the panel. And since I am the only full-time practitioner, I'll try to make them both from the practitioner's perspective. First, notwithstanding Senator Franken's remarks last night or the introduction today that kind of paints corporations in purely a self-interested light and always acting in their economic self-interest, in my experience representing technology companies for the last 10 years, it's actually been the ISPs, the wireless providers, the broadband providers who've been standing as the protection for individual liberty between the government and the users. I mean, you wouldn't think that, right, after the press of the wireless wiretapping program and blaming communication carriers for turning information over to the government. But the majority of my practice for the past 10 years since I've left DOJ, and the fact that I have an entire 7-lawyer boutique law firm that's really dedicated to representing technology companies to say no to the government, indicates that there are people out there who are worried that the government is overstepping its bounds when it's trying to collect information about internet users. The lawyers in my firm have trained, counseled, and litigated on behalf of the compliance departments of all the major ISPs and social networks in the country, from Yahoo to MySpace, from Cablevision, Cricket. All of them have placed themselves between the government and their users in trying to make sure that the government isn't overstepping. In fact, if the government hadn't packed up its ball and gone home, rather than being here today, I'd be in Colorado arguing whether the Fourth Amendment applies to opened and stored email on Yahoo's email servers over the government's claim that they could get access to that information without a warrant. So yes, EFF, yes, ACLU, yes, interest groups have gotten involved, but often when we've moved to unseal the case and then invite them in to brief the issues. So that's just one perspective, that there is trench warfare going on out there, and the technology companies are part of it. The second observation I wanted to make is really about the power and the weaknesses of the analogy. Oren started by talking about the analogy, talked a little bit on DNA about, is it really technology neutral? Is there a way to make an analogy in every circumstance? What I learned in law school 20 years ago is that you rarely get credit as a lawyer for new ideas. You get a lot of credit for taking a new idea and making it look like an old idea that the judges are very comfortable and familiar with. And as a practical matter, the person who wins the legal debates most often seems to be the person who has the advocate with the most powerful analogy. We see that in Oren's point about the box, right? If an email is a box, then it's pretty easy to determine the Fourth Amendment protects the contents of the box. If, on the other hand, the adversary says the email is like a postcard or telegraph, and every computer system and every person who sees the email, touches the email, passing it from one part of the destination to the other, can read the full contents, not the envelope is a metaphor but doesn't actually exist, then you lose Fourth Amendment protection because there's not a lot of reasonable expectation of privacy in what you write in a postcard. Sometimes the analogies are fairly simple, but when we get into more sophisticated types of communications, the analogies get more difficult. What is the real-world analogy for a friend request? We didn't make friends online before. I had walked up to you and asked you to be my friend. You'd think it was a little strange if I didn't know you. You may think I'm strange when I do it on Facebook. And what about the online photos that I share with only 6 of my online friends? If I can convince a court that this is the equivalent of inviting them over to my house for tea and sharing my photo album with them, then the photos are probably protected. But if somebody convinces the court that it's the equivalent of putting a pin on a bulletin board with 6 photos on it in a workplace where only the people who work there can see it, and there's a security guard, but generally I'm putting the photos up for public consumption, I probably don't have a lot of reasonable expectation of privacy in things I post to a bulletin board, even in a quasi-private space. So the analogy gets harder. So that's the power of the analogy. Here's the weakness of the analogy, and here's where I think the government is intentionally trying to steer courts in the wrong direction. When we were talking about the photos on the bulletin board, or in Facebook, the photos in my online album, we were thinking about me, the speaker, and the recipients who saw the photos. We weren't thinking about Facebook. But what the government has been trying to do as a litigation strategy over the last several years is to get the courts to focus on Facebook and say, by putting this information online, we've shared the document with a third party over whom we have no control, Facebook, and who has specifically asked for and gotten the rights to access the data, photos, emails, whatever's posted, under certain circumstances. So where I think the analogy gets us into trouble is, how do we square it with the third-party doctrine? The fundamental premise being that if I take documents that are protected in my house and give them to my accountant, the expectation I have at the accountant won't turn those over is much lower. I don't think when you share documents on Google Documents, in fact, when you post a document on Google Documents that only you can access and it's password protected, or you put your photos up on Adobe Photoshop Express and it's password protected, or you store your email on Yahoo, that you believe you're really sharing that content with the technology provider. You may let somebody else in to see it, or you may not, but you believe it's protected. In fact, this is one of the problems, I think, with the technology neutrality approach that Oren espouses in his Stanford article that's being distributed, is that, in fact, you have to take into account the technology to understand whether the information is more or less protected when I put it online. I mean, consider for a second the diary I keep in my bedside, right? It may actually be true that the safest place for that diary, vis-a-vis any third party seeing it, is in my bedside. Yes, it could be a fire, it could burn down, I might want to put it in the vault, but it's a pretty safe place. No one can get access to it. But when I put a document on my home computer, I don't have that same type of protection. I mean, I'm a fairly sophisticated computer user. I'm a certified information systems security professional. And every month I think maybe about the security of my home network. And I might download patches and I might take some steps. But Iron Mountain or Google Docs, they think about the security of their online environment every day. So if I want the most protection for a private document online, I'll store it with them, because they're going to do a better job than I am storing it on my home network. But the law presumes exactly the opposite. That is, if I share it with Google, even if I've got a password-protected account, even if it's encrypted, the law tends to presume it's less protected when it's out there on the cloud than it is in my bedside drawer. And so that's why I think the analogy gets us into trouble. When we think about what would be the real-world analog to that, I don't think it works so well. So the only conclusion, I think there's going to be some questions about this, is, I don't think we should restrict ourselves to that approach. We need to think normatively about whether the ISP's right to access under a terms of service or agreement with their users, whether their right to access the files or documents for the purpose of screening for child pornography or resisting viruses or searching for malware or taking down copyright infringement content, whether that's really an important consideration in determining whether there's a reasonable expectation of privacy in the document, or whether we ignore the right of an ISP to look at the data when we consider whether the government has the right to look at the data. And that requires a little different Fourth Amendment analysis than has currently been going on.
Mark, thank you so much. That was just great. What I'm going to do now is pose to each of our panelists a hypothetical, say from the year 2015, 2020, maybe it's a little bit closer. These are things that are right on the horizon. I'll give a different one to each of the four, but the others should feel free to jump in and they like. And I'm going to start with you, Susan. So I was at Google at a conference now 2 years ago. Oren and I were both there. And we heard the head of public policy at Google say that he expects that within 5 years, Google will be asked to put online live feeds from all the closed-circuit TV cameras that are now run by the state and by private companies. Imagine, Susan, that Google agrees to this request, puts and integrates all of the live feeds and archives them, stores them in the cloud. So it's possible to click on a picture of me, back-click on me to see where I came from this morning as I prepared to go to this panel, forward-click on me to see where I'm going after the panel, and basically have 24/7 ubiquitous surveillance of all people at all times within the system. Now, obviously, there's a state action question. You can do the hypo as you like. Imagine that the government is using this integrated system, some of which is public and some of which is private cameras, to search for criminals. Or if you are still not convinced there's state action there, imagine Google doesn't want to put up the system and the government requires them to do it. What I'm basically interested in, are Fourth Amendment values offended by 24/7 ubiquitous surveillance? And if current doctrine doesn't address this question, what do you suggest as an alternative to respond to it?
That's a terrific hypo, Jeff. Okay, well, for example, one of the issues in the lower courts involves GPS tracking of automobiles. So going back to what I said earlier about the court's tendency to believe that the mode of intrusion is unimportant, that if you can see something one way, it doesn't matter whether you're actually seeing it in another way. The idea is that if I drive my car to the store and do 14 errands, and I'm in my car for several hours tomorrow, lots of people could come together and try to piece together what did Susan do yesterday. She spent 2 hours going to the grocery store and the dry cleaner. That is public information. It can be pieced together, and therefore, if the government wants to do a GPS tracking device of my car for that amount of time, for 24 hours, they should feel free to do that. I think there's a logical leap there that is really important to consider and to critique, which becomes relevant to your hypothetical, which is it's a lot harder to get a whole bunch of people together and track my movements. None of those people intended to track my movements, first of all. Second of all, it's just really time-intensive and labor-intensive to do so, and it does not necessarily follow that, therefore, the government ought to be able to do so. GPS tracking just makes it a whole lot easier to intrude in my life at a level of intrusion that I'm not used to and that I don't expect. So I think we have to be willing to make those sorts of distinctions. And so the fact that Jeff might take a certain route to work every day doesn't necessarily mean that he expects it to be on camera, that he expects it to be on camera to that level of intimate detail, and that he expects that camera to be fed into a room full of people who are there for whatever nefarious reasons they might be there for. So mode of intrusion is really important. Going back to my other point, the very fact that government is involved and is intending to track is important. And the final point, the final Fourth Amendment value, and I want to say that I thoroughly agree with Mark's last point, which is that these are normative questions about what kind of government we want to have in our lives. There is no formula that's going to avoid those normative questions. So the last point goes back to what I said about indiscriminate searches. The fact that everyone in Times Square might be on camera means that no particular person is being stigmatized, and the court has been tending to say recently that that makes it okay. The fact that we're all equally burdened and stigmatized means that there are no Fourth Amendment values at stake. And I think that that's becoming increasingly problematic, that these indiscriminate searches burden all of us, and that that's a normative value that comes into play here as well.
Great. Oren, this hypo is from Jack Goldsmith, who has a wonderful new piece in the New Republic this week about cybercrime and uses this hypo, so I'm happy to pass it along. He says the year is 2020. For decades, major firms have had intrusion prevention systems on their computers, connections to the internet, but in light of terrifying new cyber assaults that make the Chinese hacking look tame, imagine that the government mandates the use of a government-coordinated intrusion prevention system throughout the domestic network to monitor all communications, including private ones. So Comcast and Google and all the ISPs are required by the government to surveil communications in real time. Imagine more concretely, the system requires the National Security Agency to work with private firms in the domestic communications network to collect, copy, share, and analyze the content and metadata of all communications for indicators of possible computer attacks and take real-time steps to prevent the attacks. Is that a violation of the Fourth Amendment? If it's not, is it a statutory violation? Are statutes necessary to address it? Does this creep you out or to make you happy?
As a former Justice Department lawyer who worked with government IT staff, the idea of the federal government taking over intrusion detection systems on the entire internet strikes me as an incredibly, incredibly bad idea. I think you say, wait, we have a detection, and they would, we have a potential attack, and they would say, we'll get to it in 9 months. Hang on there. Shut things down before we get to it. So I would be very skeptical about that as a policy answer. The government just is not very good at this sort of thing. From a constitutional standpoint, the real hook would be the special needs doctrine, which basically says that when it's a government interest outside of criminal investigations, there's a general reasonableness framework. The problem with trying to analyze something under the special needs doctrine is that you need to know all the facts. And then you generally need to know what either Justice Breyer or Justice Kennedy thinks, which neither of us know at this stage. So it's really hard to answer as a constitutional matter because it would apply under this general reasonableness framework. But I'm very skeptical about the government playing a major role in this area.
Interesting. Jack in his essay actually thinks that there's not so much of a Fourth Amendment protection and is more keen on it, and your skepticism is a relief. That's good to hear. Professor Zhou, you mentioned all of these great DNA cases, and as you know, they're not hypos, so I'll just give you the one that the European Court of Justice decided recently with a twist. Imagine that CODIS, the FBI, decides, as it's done recently, to store DNA not only from convicted felons, but from all arrestees, and then to start using familial searches, which, as you suggested, look for partial matches that would show that someone in the database is not the perpetrator of a crime, but related to them. So the famous example, as you know, is the blood on a brick that was thrown onto a truck in Britain. They run the blood through the national DNA database, and they find there's not an exact match, but a partial match. In other words, the person who committed the crime is not actually in the database, but someone related to the person who committed the crime is in the database. And based on that familial search, they identify a relative of someone in the database and then lock him up. When you start doing familial searches of arrestees, you find racial disparities. African Americans are 4 times as likely to be identified as non-African Americans. Imagine that both the storage of the arrestee DNA and the familial search are challenged as a violation of the U.S. Fourth Amendment. It's an open question, but how would you analyze it, and what do you think the result should be?
Boy, wonderful live issues. So there's 2 distinct things here that have been raised. One about the use of taking compulsory samples from arrestees, and 2 from familial searches. So I'll start with the familial searches. Again, you're just looking through the database not to find a person necessarily in the database, but someone who may or may not be related. And just one caveat here, when you find a so-called partial match, that doesn't necessarily mean that the partial match isn't going to be someone who related to that partial match. It may be. You would probably need some kind of additional, more sophisticated testing to determine that. So I think under the Fourth Amendment, I think that the obvious thing that pops out is the lack of individualized suspicion for the family member who is connected as a result of this partial match. We generally don't, we frown upon guilt by association, and in a way, what the familial search is doing is relying upon this guilt by association. And for those kinds of reasons, I think we ought to be particularly concerned about familial searches that are just these fishing expeditions through CODIS hoping to find some wider net. I mean, for that reason, it's something that some police departments have been particularly excited about because it sort of widens the net of potential suspects. But something I think as far as from a liberty perspective and a Fourth Amendment perspective where privacy is important, without any additional suspicion attached to that family member through any other traditional investigative technique, we're literally just looking to that person because they happen to be genetically related to the person who provided the partial match. As for arrestees, I think, as I already mentioned in my introductory remarks, one of the things about arrestees is they probably stand in quite a different position than all of those Fourth Amendment challenges that have thus far lost when it comes to DNA databases. So most of the challenges to DNA databases have been resolved by the courts either as a matter of Fourth Amendment reasonableness and to a lesser extent under the special needs test that Oren has already mentioned. The reasonableness tests that most courts have used have really relied on the fact that once you've become convicted, once you're in a so-called post-conviction status, you have significantly diminished expectations of privacy apart from ordinary folks out in the real world. And when it comes to that, because you have diminished expectations of privacy, the lower courts have generally said, uniformly has said, that makes it okay for law enforcement to ask or to take your a compulsory cheek swab or blood sample to be included in a CODIS. When it comes to arrestees, there's a huge gap between those who have gone through a process to adjudicate guilt and those who've simply been arrested and nothing more. And unless we are going to say that somehow the mere fact of arrest diminishes your expectation of privacy significantly, I think here the arrestees have a pretty good shot at saying that they stand in a different position. And we'll see there's actually a pending case in California under California's Proposition 69, Haskell versus Brown, as to whether or not this is indeed a Fourth Amendment violation. And one additional point that makes it particularly problematic, I'll just throw this in when it comes to arrestees, is that realize that once arrestees become part of the database, we are now relying upon not what we hope is a neutral process for adjudicating guilt or innocence and then saying, here's this person who has been convicted and thus that person has to provide a compulsory sample. We're essentially relying on police discretion to decide who's going to be put into that database if we're expanding the pool to arrestees. And one disturbing thing is that it also leaves the field wide open to officer discretion. The Supreme Court has pretty much had a hands-off approach when it comes to police discretion and the Fourth Amendment. And then we'd begin to worry about the reasons why police were arresting. And not to sound too sort of paranoid about this, but for example, one thing we might worry about is maybe police start to arrest people for the purpose of having their DNA sample taken. It's not such a crazy idea. Again, this UK Human Genetics Commission report that I alluded to in my opening remarks had comments from current and retired British police officials admitting to that such practices, that yes, sometimes we are arresting people because we'd like to have their samples included in the database. So a wide range of concerns.
Fascinating. And Mark, this may not be strictly a Fourth Amendment question, but it is, according to recent polls, the privacy question that people care most about in the internet age. And this is the inability to delete your past, the impossibility of digital forgetfulness. So the drunken Facebook picture is the paradigm case. There's this now famous woman called Stacy Snyder, who was a would-be student teacher. She was about to graduate, and her employer Googled her on Facebook and saw a picture of her wearing a party hat, drinking from a plastic cup with the caption, "Drunken Pirate." She was fired from her job as a student teacher and didn't receive her teaching degree and is now working as a result as an au pair. She sued, and for technical reasons, the finding was that she was a public employee and had a reduced expectation of privacy. She lost. So you can analyze this, I don't know, you can create a state action element if you want, but basically, I just want to know, based on your experience, what is the solution to this problem of the inability to escape your past? Is it new legal causes of action, like the ones that Brandeis proposed a century ago, where you can sue for people betraying your confidence when they share Facebook pictures, or you could sue employers for not hiring you or firing you based on legal off-duty conduct? Is the solution technological? Should Facebook be required to delete these pictures after 3 months, or if you don't ask them to be stored forever? Is it social norms? Do we need to be more forgiving? What is the solution to this greatest privacy question of our age?
Right. So it's an excellent question, and I agree with your premise of it, which is it's hard to make this a Fourth Amendment question. When I was worried about the third-party doctrine before, I was worried about when you give somebody access to your data for X purpose, it doesn't mean they can use it for Y purpose, and it doesn't mean that somebody else can piggyback on that. When you publicly share data for any purpose with a broad range of the population, it becomes very difficult to find a useful cause of action, I think, to enable that to come back. There is a caching concept in the DMCA which says that when a internet service provider caches material that you had previously put on the website and then the material has changed, for them to maintain their caching immunity under the DMCA, they have to respond quickly to a request to change the information they have in their cache, so they're not having inaccurate information when the website has changed. So if they don't do that, if they don't respond quickly to remove this from your cache request, they could be liable for copyright infringement and other causes of action because their safe harbor goes away. So to the extent that this is a concern, I think it's a concern that we have to do something about proactively and legislatively, because it's not something that I think you can really do much with currently. But it wouldn't be a stretch to condition the immunity for a service provider for not being liable for the user-generated content on their site with having a policy that requires them to delete user content when it times out or respond to user requests. If you look at California's privacy rights statute, for example, they say, you're allowed to share user data with third parties, but you must either give them a right to opt out of that before the sharing occurs, or you must respond to their request at least within 30 days and at least once a year if they say, who do you share my information with? So we have models privacy statutes that are completely divorced from the Fourth Amendment that require ISPs to respond to users, that require them to take action to delete information. I don't think those would be stretches to try to apply something like that to solve the Stacey Snider dilemma, but I don't think the law currently does a very good job of it.
Very interesting. Just because I'm curious, would that solve the problem of those time machine caching systems that cache everything as a matter of course?
Well, those are very interesting for a different reason, right? Because the ability to be a whistleblower, the ability to bring things to public light, depends on you being able to notice things, store things that were on the internet last week and that aren't on the internet now. So the Wayback Machine and archive.org, those types of things, the dilemmas they face, when I'm counsel to them and they're asking, can we scrape, can we preserve, can we maintain, can we run a cloud preservation service, is do the terms of service of the initial site allow you to scrape, and do you respect their robots.txt file, which is the file that tells search engines whether or not they can go to the site. There's value in being able to preserve what was on the internet. And so, I was testifying before the Senate Judiciary on the question of video surveillance, and the question was, do we want a statute that makes video part of Title III? And the answer is maybe, but video has value. We protect ourselves. We protect our children by having video in public places. We don't want no video in public places. We don't want no video in ATMs. So we don't want no preservation of what was on the internet because it's the only way to bring the truth to light sometimes. So I do think this is an area we have to worry about a balance.
Great. Thanks to all of you for those very thoughtful responses, and we're now ready for questions. Yes, sir.
Sean Hitchcock, Human Rights Defense Committee. I'm curious about to what extent the national security regime essentially eviscerates whatever might remain of the Fourth Amendment in the routine criminal context. And I just want to, I guess, a comment for Professor Joe and a question for Mark. Professor Joe, you'd mentioned the sort of danger of pretextual arrests to essentially, for no purpose other than to collect intelligence. The NYPD stop and frisk program, which has a 9-to-1 disparity in black to white, has been defended on precisely that ground, that the intelligence collected from this stop and frisk program, while it has no empirical effect on crime, is useful because it's feeding a database of non-criminal information that is presumably, usable somehow. And the question for Mark, so a lot of your clients, I suspect, are in the Digital Due Process Coalition, which has been behind a series of proposed amendments to the Electronic Communications Protection Act, which are great. They relate a lot to the cloud computing stuff that you're articulating. But it all relates only to routine criminal scrutiny. And I wonder if, given the systematic overbreadth of national security, NSL abuse by the FBI, for instance, is there any meaning, is there any teeth to Fourth Amendment protections in this context?
So, two responses. First, in the spirit of full disclosure, I am a member of the Digital Due Process Coalition. I'm the only practitioner who signed on to it. So I can't talk about too much of the interior discussions about it, except that it was easier to find consensus on issues around criminal than to get companies to take a position on national security and intelligence. I will say that where I don't share my colleague Oren Kerr's optimism on the Fourth Amendment is the continually carving out and expanding the special needs exception to take into account intelligence needs. The decision came down this year or last year from the Foreign Intelligence Surveillance Court of Review that basically says there is a exception to the warrant requirement for national security investigations, for foreign intelligence anyway, and that there isn't the need for the involvement of a neutral and detached magistrate, that as long as the executive branch follows a reasonableness test that they apply to themselves and follow themselves, then under the Fourth Amendment there can be legitimate acquisition of contents of communications. And that worries me. I worry more about the absence of a neutral and detached magistrate than I worry about what the standard is. When we start to debate new things like location data, there's a push really for the standard to be the highest. But as we've seen, magistrates deny requests under lower standards all the time for information. So the involvement of the neutral and detached magistrate to me is important, even more important sometimes in the standard, and I worry in the national security, foreign intelligence context that that's being eroded.
Yes, sir. In the front.
So, Mark, your point about cloud computing and how the cloud is actually more secure than this
can be,
is well taken. But it also raised in my mind, what role is subjective ignorance going to have to play in our Fourth Amendment jurisprudence? And what I mean by that is that so when you think back to the telephone cases, most people know that when they dial a number, it's being sent to some phone company somewhere, and so the Supreme Court has said that because it's reasonable to expect people to understand how that works, it's also reasonable for them to expect they don't have privacy in those numbers. But the internet is really complex, and most people do not know that a well-regulated cloud is probably more secure than their home computer. Most people probably do not know when they posted an anonymous comment on my blog how ridiculously easy it is for me to figure out who they are. And I don't necessarily think that it's reasonable for our jurisprudence to expect them to figure out all of these details for the sake of enforcing their Fourth Amendment rights. So, does that mean that when you or I, who understand cloud computing, post something on the cloud, it has different Fourth Amendment status than when the average person does it? How do we deal with the fact that people can't know when they're standing up for the rights as well as they could when it was simply a question of, well, either the cop is in my house or he's not in my house?
Right. This is where the appeal of Oren's article and Oren's approach, I think, and she should comment on this as well, is very well taken, because you don't have to know. You have to know the type of communication you're engaged in and whether you have a subjective expectation of privacy in that, and then we need to make sure that society recognizes that as objectively reasonable. I will point out that, when we talk about Katz, right, the phone case, there wasn't a lot of discussion in Katz under what circumstance the operator could break into the call and listen to the call. Right? There was a decision that the call was entitled to protection of the Fourth Amendment with no discussion of the phone company's tariffs and under what circumstance the operator can break in and how often the operator can listen, and that wasn't important to the decision. But if we had that same discussion now about cloud computing, I can imagine there'd be a lot of debate in every part of the pleading and in the decision about under what circumstances other people can get access to it. So when you have a decision like Katz, you can get to the right answer without having to know the technical details of how it connects. It just depends on what people expect for the communication. But let me throw that to Oren, because I think you're...
Yeah, I think it's very hard to base Fourth Amendment rules on misunderstandings of technology. Ultimately, the courts are crafting rules based on normative conceptions under the reasonable expectation of privacy framework. And the subjective expectations, even though it's technically we always talk about the two-prong test. The first prong doesn't matter. There's no case that I've ever been able to find where it actually was the grounds of the court's decision, where they wouldn't have reached the same result if they'd gotten to the second prong. And I think the problem is these understandings very quickly become outdated. And an example of this, there was a case, I think, from 1999, United States, I think, versus Genus Perez is the name, from Puerto Rico. And a guy had posted a photograph of himself on a website. This was sort of late 1990s, maybe 97, 98, in which it had been under construction. Remember when you used to make a website, have the little digging guy under construction? That meant like my website is sort of half made. And so what his claim was that he had a reasonable expectation of privacy in his publicly available website because it was under construction and therefore not yet available to everyone. And the court's like, wait a minute, that doesn't make any sense. And that's a claim that today is utterly preposterous, and even back then was a bit of a stretch. But the idea of following our current conception of how the technology works, I think, is a bad idea.
I recognize that this is difficult. I mean, that's why I'm posing the question, because I think it brings a level of complexity to the Fourth Amendment that hasn't been there before. I guess what I'm saying is that there's a difference between the case that you're describing and reasonable ignorance. You know, there are things that you just can't expect people to understand about the availability of stuff about them on the internet to someone who really knows how to search for them.
Right, and unfortunately, I think that's why the difficulty of a search occurring is generally not factored into whether something counts as a Fourth Amendment search. So if you live, as the court said, I think it was United States versus Ross, whether you live in a great neighborhood or a terrible neighborhood doesn't make any difference as to whether your house has a reasonable expectation of privacy. It does, by virtue of it being your home. So I think the same approach as applied to the internet would say it doesn't matter what a person's subjective understanding is of the technology, or maybe what the exact details of the terms of service are that no one reads. It's more the state of the contents as contents remotely stored that generate the protection.
I just want to add that it's about what we can be expected to understand, but there's also the consent aspect. The court's also assuming here that if we did understand that, for example, our phone numbers were going to the phone company, which we certainly do now, that we could somehow opt out of that. And even as to the telephone and our bank records, that isn't really a viable option. And certainly in the internet age, it's become less and less of one. People might not want to post anonymous comments on your blog, but a lot of the other things we do on the internet, we really don't have the option to opt out of. And I don't think the court has really acknowledged that.
Yes, sir, in the back.
Thanks very much for coming to speak to all of us. I'm curious to know to what extent you think new technologies are changing what society views as a reasonable expectation of privacy. There seems to be a culture of people sharing a lot about their lives in light of some new social networking technologies. And to what extent will courts be shifting their views and understandings of what constitutes reasonable expectations of privacy, and would some sort of empirical studies help inform them as to what society does view as reasonable, and do you see that changing over time? Will courts be reacting to that?
If you don't mind my taking that, I've just seen a really interesting study by Chris Hufnagel at Berkeley, who does the first comprehensive survey of the privacy attitudes of younger people and completely explodes the conventional wisdom that young people don't care about privacy on social networking sites. He's finding that, on the contrary, as people in concrete ways are experiencing these drunken pictures being taken out of contexts and losing jobs and being fired, they're very concerned about privacy in ways that don't differ all that much from older people. They want laws to be passed to protect privacy in particular contexts. So it's an empirical warning against the dangers of generalizing about generational trends. In terms of empirical studies, there's been some great work done by Christopher Slobogin at Vanderbilt, who gathers focus groups of jurors and students together and asks them, what is your expectation of privacy for the following searches? And Slobogin finds there is no correlation between what the Supreme Court says people expect and what they actually expect. The stuff that's at the bottom of the Supreme Court's list, like emails surveillance, is at the top of people's list. The Supreme Court says people are not concerned about being searched at the border. The focus groups say that's what they're most concerned about. So just a little bit more empirical work in this area would be useful, and there are beginning to be studies along these lines. Go ahead, Oren.
I actually think the Supreme Court is right in this area, and Professor Slobogin is wrong, because a reasonable expectation of privacy is not whether a reasonable person would expect privacy. and you think, wait a minute, it sure sounds like it is. And that's because reasonable expectation of privacy, or probably better expressed as legitimate expectation of privacy, is really a normative policy call. It's a legal fiction in which the courts are looking at normatively, should this be protected? So I think subjective expectations, sort of our sense of is it likely that this information will become disclosed, is not where the doctrine is and not where it should be, in part because that's so easy to manipulate. And I would offer, probably most of you, the first time you used, say, a web browser, thought what you were doing was sort of going into this special private world, right, where you sent off into information and it sent it back to you, and you were in this little cloud. And then someone walked up and pressed the history button to see all the places that you've been. You're like, wow, I had no idea this information was actually being recorded. And it's that experience. What is your expectation of privacy? It's based on perceptions as a user, which may not have any connection to what's actually happening. So I think that the empirical question is actually not as helpful as the normative one of what should be protected.
Can I take on just a slight? Part of your question also talked about how judges react to this and how they consider it, and I keep thinking about this because I guess I'm preparing for another topic on location data. But in 2006, the magistrates were looking at the question of the location data given off by your cell phone. And they were analyzing the question of whether this was something that really related to the user and was it being stored for the user's purpose. And one of the magistrates went into this very long discussion about how a user doesn't really understand that their cell phone's on, is always checking into towers, and it's always giving proximate location data, and that this is just unknown. They have a phone for a call, and they don't realize it's being tracked. And I'm reading this while I'm wearing my Garmin GPS watch, getting ready to go for a run, and looking at my Google Droid, which is on nav, telling me exactly where I need to go to meet my running group. And I'm thinking, really? Like, I pretty well understand that the whole reason I bought both of these devices is to track me everywhere I go. So I think judges do filter a lot of that into their jurisprudence, and I don't think it holds up even 2-3 years when they do that. So
I'll just throw in one additional thing about DNA evidence. I think with DNA, we're also a little bit schizophrenic right now. I think on the one hand, when you say one of the alternatives to the growing numbers of groups to be put in databases, for example, is to say, why don't we just stick everybody in? They'll just make it easy, no racial discrimination problems, no nothing, right? Everybody's in, not a problem. And there's often great resistance to that. So that suggests a high degree of expectations about privacy. On the other hand, many companies offer your DNA profile on a T-shirt, on a coffee mug, on a giant canvas to be put in your living room. President Obama, when he was on the campaign trail, his half-eaten breakfast was put on eBay with his DNA on it as it was advertised. So we're in some state of flux about that. We're not really sure whether DNA is just something that nobody really should care about, or we should care a lot about, depending on who has it.
I have just gotten the hook signed, so I think that I will thank our panelists very much for a fascinating discussion. And ladies and gentlemen, before you applaud, let me say that we are here for 15 minutes of networking, which sounds creepy, but I think means we're all going to talk to each other for as long as you like. And after this session, Linda Greenhouse will be signing her books in the cabinet room until 5. Representative Sanchez will be in the grand ballroom at 5, and there will be a plenary panel on immigration reform at 5:30. Thanks to everyone for a wonderful discussion.